Hello, everybody. Welcome back to Patriot's History. I'm Larry Schweikart, co-author of Patriot's History of the United States with Michael Allen. I'm also your host here in this show. And we are reading through Patriot's History of the United States. Again, for most of you, we're using the 15th anniversary edition. Now, it's not going to matter today, but in most cases, even if you have an older edition, it won't matter as long as you can line up the headers, because I will always give you the header. But for the last 2 or 3 sessions, we've been looking at the U.S. Constitution and reading through that. And so today we're going to continue with Article 1, Section 9, the legislative branch limitations. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 per person. What's this all about? This is the slave trade. And so basically they agreed we won't touch the slave trade until 1808. And at that point, Congress banned the slave trade, okay? But they gave them basically a 20-year reprieve on the slave trade, but they did say Congress could tax the slave trade. To my knowledge, they did not. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. So you can't throw people in jail like the J6 prisoners and keep them forever without charging them. Charging them is just part of it, though. You have to have a speedy trial, which has absolutely been denied these poor people. It's horrendous. No bill of attainder or ex post facto law shall be passed. An ex post facto law is an after the fact law, which says we're going to make it illegal for anyone to have a Chevy Camaro, effective as of 1985. Well, it wasn't a law then, precisely. You can't go backwards and pass a law that makes something illegal that already happened, just so you can get somebody in jail. That's called an ex post facto law. No capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. So you can't have a direct tax on people unless it's in proportion to the census. And it has to be done before you can lay the tax. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. So the federal government can't favor, let's say, Savannah over New Orleans or New Orleans over New York. No tax or duty shall be laid on article exported from any state. We do not have any export taxes. We have import taxes. You can tax things coming into the country, but you can't tax American manufacturers going out of the country. No preference shall be given by any regulation of commerce or revenue. I just read that one. Sorry, I skipped one. No money shall be drawn from the treasury, but in consequence of appropriations made by law and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. So Congress has to appropriate the money, and then they have to allocate the money. They appropriate by saying we're setting aside this amount of money, and they have to say here's yours, here's yours, here's yours. And then you have to publish records of what you've done with all that money. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept or present emolument, office, or title of any kind whatsoever from any king, prince, or foreign state. So in America, not only is it forbidden for the United States to make you a Duker account or something like that, but you cannot be made a Duker account by another country. You can't hold that title. Now, we do have our Medal of Freedom. That's not quite the same thing. That's an honor. It's sort of a civilian version of the Medal of Honor, and that's been given to a number of people. Section 10, state powers prohibited. No state shall enter in any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law or law impairing the obligation of contracts, or grant any title of nobility. These were strictly things related to the federal government. Now, here's two ways you can read this phrase about coining gold. One is you can say, see, Schweikart, they only wanted the gold standard for the United States. Now, remember, I went over this last time. It does not say that, and it implies paper money is okay. It implies that, especially when you talk about changing the value, which is hard. It's not impossible, but it's hard to do with silver or gold. But what they did do was to prohibit states from minting or coining their own money. And I think this was because they anticipated there would come a time when they might have to print money, like in a war. And they didn't want a state saying, oh, use our Connecticut gold dollars. They're better than US notes. In other words, they did not want the states competing with the federal government in terms of money. I think that's what that's all about. I could be wrong, and you could make an argument that they really didn't want anything but gold, but I don't think that's the case from my reading in banking history. Notice also states are prohibited from impairing contracts, issuing bills of attainder, creating ex post. In other words, all the things that the US Congress cannot do, the states can't do either. No state shall, without the consent of Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection law, and the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to revision and control of the Congress. In other words, South Carolina could lay a duty on certain types of imports or even certain exports only insofar as it was required to pay the costs of state commissioners or accountants or whatnot. However, notice that all the money from said regulations and imposts goes where? To the feds. And this was the federal government's way of keeping the states from levying their own export taxes by saying, well, you can levy them, but you're not going to keep any of the money. So why levy them in the first place? Although today, if I may, sorry, if I may, I could see how woke states like New York or California would want to levy certain exports to harm them, to punish them for not being woke enough or whatever, even if the money went to the feds. I could see them do it just for punitive purposes. They're that evil. But we'll see. I haven't seen it happen yet, but it won't surprise me. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in times of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded or in such imminent danger as will not admit of delay. Now, did you catch that? You can't enter, excuse me, into a compact with another state. You can't have these compacts that say, well, we will give all our electoral votes to whoever wins the popular vote. Well, I know states have done it, but you know why the Supreme Court hasn't struck it down yet? Rightness. This whole concept that a a doctrine or a law has to have harms. And until it shows harms, in other words, until it's real, the Supreme Court's not going to act on it. It's just a hypothetical. And the Supreme Court hates hypotheticals. They absolutely will not engage in hypothetical cases. So right now, I forget how many it is, but you have a number of these states that have entered into this compact, excuse me, I seem to have a frog in my throat, that have entered into this compact to whoever wins the popular vote gets all their electoral votes, even if, let's say, Donald Trump won Georgia's electoral votes, but lost the popular vote nationally. Georgia, under such a compact, would agree to give its electoral votes to whoever won the national vote. In other words, trying to undercut the Electoral College. And this says you can't do that. And the only reason it's not been acted on is right now it's not a threat. Now, if you get to the point where enough states have signed on to such a compact that could throw an election, I think you would immediately get a suit filed. And I think the Supreme Court would immediately expedite it and rule against it. But you're not going to see that till something becomes real. Article 2, the executive branch, Section 1, President. The executive shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President chosen for the same term, be elected as follows. Each state shall appoint in such manner the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which that state may be entitled in Congress. So if you're Alaska and you get 2 senators and, I don't know, 1 congressman, you get 3 electoral votes. Or if you're Arizona, you get 2 senators. I think we have 9 congressmen. You get 11 electoral votes. But no senator, representative, or person holding an office of trust or profit under the United States shall be appointed an elector. The elector shall meet in their respective states and vote by ballot for 2 persons, of whom 1 at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all the persons voted for and the number of votes for each, and the list they shall sign and certify and transmit to the seat of government of the United States, directed to the President of the Senate. This would be to the Vice President, the sitting Vice President. The list they shall sign and certify and transmit to the sealed seat of government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and the House of Representatives, open all certificates, and the votes shall then be counted. The person having the greatest number of votes shall be in the President. If such number be a majority of the whole number of electors appointed, and if there be more than 1 who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot 1 of them for president. And if no person shall have a majority, then from the 5 highest on the list, the said House shall make in like manner choose the president. But in choosing the president, the vote shall be taken by states. So if you get to the House of Representatives, if it goes that far, you don't have a clear winner. Say it's a 269-269 tie. Then you vote in the House, but not by House members, by state delegations. So for example, right now, the Republicans have a 6-7 vote edge, maybe 10, I forget, in the House, between 7 and 10. You never know who's absent, who's died, and whatnot. But last I looked, the Republicans had something like a 36-14 edge in state delegations. meaning more Republican members than Democrat members. So this nullifies California's edge, New York's edge, Texas's edge, and Florida's edge, because they only get one vote each, the same as Vermont, Hawaii, New Mexico, Idaho. See, so the small states are protected if it goes to the House of Representatives. Now let's go back to this reading of the votes, because this is very controversial. The electors shall meet in their respective states and vote by ballot for two persons, one of whom shall not be an inhabitant of the same state as themselves. What happens if you get multiple slates of electors? This has happened. In Hawaii in 1960, there was an initial ruling by the governor that Hawaii had gone to Richard Nixon. Then they did, and that was sent in to Congress. And by the way, the slate goes to the President of the Senate, the Archivist of the United States, and to a federal judge in the district in which the state legislature is located. So those slates go to three persons. My understanding is you cannot have a slate come in that does not go through those three people organizations: President, Senate, Archivist of the House, Judge. So in Hawaii, they sent in one slate, said Nixon won. But then they did a recount very quickly, and they concluded Kennedy won. So the state legislature sent in its own slate of electors saying Kennedy won. Now, my understanding, this is really convoluted, my understanding is that the governor then kind of recertified the legislature's slate, sent in a third slate. So which one does the President of the Senate open? He's got three envelopes there from Hawaii. And this opens the door to the claim that in 2020, Mike Pence had the authority under the Constitution to select which slate he would look at, or to even say, no, this slate is in dispute according to the state legislature or according to people in the state. It must be returned to the state legislature to be reviewed. There are those, including Robert Barnes, a lawyer who's gone into this a great deal. There are those who argue that Pence had that authority. There are others who argue that Pence did not have that authority, but what he did have was the authority to entertain a challenge. And there was a challenge planned on January 6th before the police let in all the rioters, so-called rioters, all the protests. You've seen pictures of them walking in, just walking quietly with their cell phones, taking selfies. There's no rioting. There was in some part of the Capitol where there appeared to have been agitators, and no one yet knows who those agitators are. Christopher Wray of the FBI has refused to provide any evidence whatsoever on how many federal agents were in that crowd that day. But that said, when that occurred, everybody ran like frightened little squid pickles, and they ran fearing for their lives, they said, from this crowd, a guy in a Viking helmet taking selfies. Anyway, they ran, and the result was a challenge by one senator and one congressman. I can't remember who it was. I think it was Josh Hawley of Missouri was the senator. I can't remember who the congressman was. They were going to raise a challenge against several of these slates from Michigan, Arizona, Wisconsin, Pennsylvania, Georgia, because there were claims of fraud in all those states. Now, supposedly these have been adjudicated. They have never, ever once entertained an evidentiary hearing. That is a hearing where both sides present evidence. Every single one of these cases, except Arizona, was dismissed for standing. This is just my opinion, folks. I'm a U.S. citizen. Therefore, I think I have standing in any federal election. Any federal election affects me. So I have standing. Courts don't see it that way. But in the state of Arizona, there was a recount in the governor's race of 2022 and a challenge that was allowed by a judge over the key issue here. And the key issue was ballot signature match for all the mail-in ballots. You see, if you don't have ballot signature match, you sign your name Joe Blow, but they could sign anybody else's name on any number of phony ballots and send them in. And if you're not matching that to the person who lives at that address and their signature that's on file, because all the signatures are on file, there you go. These don't look anything like each other at all. They're illegitimate. Until you do that, you don't have any control of the fraud. So I want to say that not one single evidentiary hearing was allowed. Not one time in the 2020 cases did they allow any signature match on all those mail-in ballots. And this was the subject of that movie by Dinesh D'Souza, where that all of these ballots were coming in from suspicious sources, and nobody could ever do a signature match. Hence, all those lawsuits were tossed out. So what the challenge was about on counting day, January 6th, was Hawley and whoever the congressman was were going to challenge these states, at which point it was argued by constitutional historians. Pence had the authority to then say the two houses shall adjourn and meet to discuss and rule on the challenges. And at that point, we know what would have happened in the House of Representatives. Nancy Pelosi would have just said, challenge rejected, boom, out. And they would have been out in 5 minutes, no question. But in the Senate, there was hope, maybe even some reason to believe that the Senate would have at least looked at and debated some of this evidence of fraud. But that didn't occur because Pence didn't allow it to occur. And so that's why, folks, if you're wondering, Pence is so disliked in so many quarters, is because the previous weekend, he had stated 2 times publicly that he was going to entertain the challenges, that only legal votes would be counted, and he would, he was going to uphold the Constitution. And then he just accepted everything. Now, what we're going to see as we move along, that 2 times we have had challenges come up just as I have discussed. And 2 times they involve sitting vice presidents who got to rule on their own election. And surprise, surprise, in both cases, they let the votes go forward that were in their favor. But we'll get to that next time. All right, I wanted to discuss all that because I know it's a thorny issue today. So the question then remains, I think, and hasn't really been solved. What authority does the vice president have as president of the Senate? It says they shall count the votes. To count them, you have to receive them. Do you accept every electoral slate given to you, even if you know it's fraudulent? If you suspect it's fraudulent, or what do? Well, the rule is that you are allowed to entertain a motion from the floor. That wasn't done. So that's where things stand. Let's see. And we looked at how the House chooses the president. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of president, the person having the greatest number of votes of the electors shall be the vice president. But if there should be remain 2 or more who have equal votes, the Senate shall choose from them by ballot the vice president. So the Senate picks the vice president. There's a tie for vice president. Now, understand this. They were thinking that in those days, every state would cast its votes for a favorite son. If they had, say in Georgia, a Georgian running, that they would cast one of their president, vice president votes for the Georgian and the other for whoever they really wanted for president. And this proved to be a problem. And you could end up, as we had happen, with Thomas Jefferson, a Democratic Republican, as president, and Aaron Burr, a Federalist. He's all over the map, but he was a Federalist as vice president. In other words, you could end up with a Republican president and Democrat vice president, or Democrat president, Republican vice president. So we're going to see, they're going to change this quick, fast, in a hurry, because that was a problem. All right. The Congress may determine the time of choosing of the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. So you must have a day set where all the states turn in their electoral votes. No person except a natural born citizen or citizen of the United States at the time of the adoption of this Constitution, so that included virtually all of the founders, including Alexander Hamilton, shall be eligible to the office of president. Neither shall any person be eligible to that office who has not attained to the age of 25 years and been 14 years a resident of the United States. In case of the removal of the president from the office, or his death, resignation, or inability to discharge the powers and duties of said office, the same shall devolve to the vice president, and the Congress may, by law, provide for the case of removal, death, resignation, or inability both of the president and vice president, declaring what officer shall then act as president, and such officer shall act accordingly until disability be removed or the president shall be elected. In other words, even before the 25th Amendment, they had a way of dealing with a president who was totally incompetent, deranged, crazy, in a coma, whatever. Same thing for the vice president. The president shall, at stated times, receive for his services compensation, which shall be neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States or any of them. You can't get special money from your home state. Before he enter on the execution of his office, he shall take the following oath or affirmation. Now, I want you to listen to this real closely, because we talked about this earlier. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. I argue that we are all under the authority of the Constitution, not a person. And if that person is not upholding the Constitution, he does not have authority, biblically speaking, because our authority isn't the person. Our authority is the document. All right, we'll pick up here next time with section 2 of the presidency. Remember, folks, I'm trying to turn Patriots history into the next Sound of Freedom, the next Chosen, the next Sons of Liberty. Help me out. Go to the website, and there's a button on there to view the trailer. Trailer is awesome. Buy me a coffee. We're getting some traction with this. We can do this, but I need everybody out there who watches these. Hundreds and hundreds of you people watch these things. One coffee each, and we'd be able to start production on this. So buy me a coffee, and I'll see you guys back here Monday.